So, bon après-midi, mes amis. I'm quite intrigued by this idea of the rights of nature. And I'm reminded of something Gandhi said when he was invited to London the first time, and he was given a tour of the city and shown the great institutions of power and learning. And he was asked, "So, Mr. Gandhi, what do you think of Western civilization?" He said, "I think it would be a good idea." And the same thing can be said of the rights of nature. I think it's a great idea. I'm drawn to it intellectually, I'm drawn to it emotionally, but because I'm a litigator, everything looks like a lawsuit. So what I'm most interested in is how is the doctrine and the concepts and the principles embodied in this noble enterprise faring when it actually enters the courtroom. So I start with, in the United States, the wellspring of our, such as it is, thinking about the rights of nature comes from, of course, Christopher Stone's famous essay, "Should Trees Have Standing?" And I've given you a link here, I'm not going to play it, to Christopher Stone's interview on the 40th anniversary of his landmark essay, and talking about what difference he thinks it has made in the evolution of sort of law, morality, environmental law, in particular, in the United States, and I commend that to you. It's interesting, of course, that Mr. Justice Douglas, probably the strongest environmental justice we've ever had on the United States Supreme Court, was quick to seize on Stone's essay and say, well, why not? Why shouldn't trees have standing? Why shouldn't mountains and rivers be treated as legal persons? After all, we treat corporations that way. We treat ships in admiralty that way. We treat estates that way. There's all kinds of things, inanimate things, of perhaps far less importance to life on Earth and human beings than corporations and other forms that we've given legal status to. He was writing in dissent. He did attract the vote of William Brennan, his progressive colleague on the court, and there it sat. We also have kind of a rich tradition in the United States of looking at these questions, this notion of the rights of nature and environmental ethics goes back a long way. Roderick Nash's seminal work still resonates, I would say, in many quarters. And of course, in the popular literature, we have the same sort of traditions that have recognized that nature needs a voice in our decision-making in some way, shape, or form. There's rich literature now, recognizing the rights of nature. Here's a shout out to Cormac and his wonderful book, Wild Law, and many other great scholars working in this space. My good friend Mims, Mary Wood with Nature's Trust, Copper and Nate with the Ecology of Law. But now the question becomes, as the saying goes, no plan survives first contact with reality. And the question is, what happens to these grand notions and doctrines when they actually encounter the legal system? And the following slides are just a very sort of brief tour of the world, looking at how some of these concepts of the rights of nature are faring in courts in other countries. And then we'll take a last look at what we might expect here in the United States. Don't get your hopes up. So this is the Whanganui River and the Maori Iwi tribe. And this is the culmination of a 140 or 160 year battle in the courts of New Zealand, fighting for the rights of the river to be recognized as a legal person with all rights and responsibilities there too. This is their chief negotiator that finally negotiated the deed and agreement that was ratified and entered by the Supreme Court, or the highest court in New Zealand, just this year. And so now we have Te Awa Tupua, the Whanganui River Claim Settlement Deed. And I've given you a link there to what is a quite moving speech on the floor of the New Zealand Parliament by the sponsor of this legislation, entering it into the law of New Zealand. And it is quite an extraordinary document. So this river, now known as Te Awa Tupua, is an indivisible and living whole comprising the river from the mountains to the sea, incorporating its tributaries and all its physical and metaphysical elements, is a legal person with the same rights, powers, duties, and liabilities of a legal person, raising the question, could it be sued for floods? And 3, title of the riverbed will be vested away from the crown and placed in the name of the river itself. Of course, humans have to be appointed as guardians, 2 specifically, 1 nominated by the crown and 1 by the Maori, the iwi, as guardians of the river. And then there's an advisory body that's roughly parallel to what we would call a kind of a stakeholders group with local authorities, national representatives, a variety of people with interests and a stake in the river's management and care. The 4 principles down at the bottom there are what are supposed to guide all the various strategies and documents and consultations that go with the management of the river. The river is the source of spiritual and physical sustenance. The great river flows from the mountains to the sea. I am the river, and the river is me. I stole that from the title of this talk. And the small and the large streams that flow into one another and form one river. So at least in New Zealand, they have a clear concept of what catchment means and what watershed means and what ecological address means. Would that be the case here in the United States? And there's some more detail here for those who want to pursue this in more depth on exactly how. There's a very intricate architecture here for the way this is all going to be managed going forward. I think it needs to be said that this is unique to New Zealand. It's unique in the culture and history and relationship of the indigenous peoples of New Zealand, which have exercised tremendous influence, not necessarily promptly or quickly, but over time in all kinds of natural resource management questions, fisheries, and other things. So a terrific example of how recognizing the inherent value, the biocentric approach to looking at river systems can work in a jurisdiction that wants it to work. Moving on to India, and not long after this great accomplishment in New Zealand came a very interesting decision by the Uttarakhand High Court in India, recognizing those 2 great river systems, the Ganges or Ganga and the Yamuna rivers, as persons, and giving them all the rights of human beings, citing the New Zealand case as precedent for this decision. This is the Ganges with the famous Taj Mahal in the background. And this is the Yamuna river with the classic sort of Indian architecture. These are some of the problems. I mean, these are heavily polluted rivers. They're also, of course, sacred rivers with great spiritual significance, but heavily polluted, primarily from sewage, untreated sewage, and lots of untreated industrial discharges and huge withdrawals from the river systems for agriculture. Perhaps a temporary, maybe hopefully setback, the government of Uttarakhand, I can't say that very well, filed an immediate appeal to the Indian Supreme Court and obtained a stay of the lower high court's decision. It's not clear to me because it's very hard to trace what's happening within the Indian legal system as to whether this is a purely jurisdictional, procedural kind of step in the process, or whether or not the Supreme Court is going to overturn the decisions of the lower court. We'll have to wait and see on that. But for the time being, a very quick replication of the success in New Zealand. Then looking at, and I'm surprised this slide is here. I guess I'll take it in this order. This is a very recent case inspired by these two victories in India and New Zealand, filed here in the United States in the Federal District Court in Colorado. As you see here, the caption of the case is the Colorado River itself versus the state of Colorado. And it too is seeking to have the river declared a person, legal person. This is from the complaint that's filed by the Deep Green Resistance as next friend of the river. And no one can really argue with the premise here. Environmental law has failed to protect the natural environment because it accepts the status of nature and ecosystems as property while merely regulating the rate at which the natural environment is exploited. Its failure can be seen from the worsening conditions, the continued pollution of ground and surface water, etc. And recognizing standing on behalf of the ecosystem itself is likely to lead to a better outcome. The problem I have, and this is a note of caution, with this particular case in Colorado, is that I'm not convinced the United States is ready for this kind of bold, creative jurisprudence. And here's where advocates have to take into account and own the potential unintended consequences of their actions. Right now in the United States Congress, which is in quote-unquote enemy hands, there are many bills pending that would totally eliminate citizen suits, wipe them off the books. And if they can't do that, they'll cripple them in every way they can, including eliminating recovery of attorney's fees, which is, of course, what fuels much of the citizen litigation in the United States, which has driven our environmental policy on so many fronts. And this kind of a case plays right into the hands of the people that say, there they go again, the crazy environmentalists. Next, they'll be telling you can't mow the grass because the grass can sue you and stuff like that. And we're already seeing and hearing that. So there is very definitely a danger of backlash in pushing some of these theories into our court system. Here's another shout out to Cormac and his great innovation, he and others, the International Rights of Nature Tribunal. He's already talked about this, so I'll move along. Let's see what's happening in Ecuador. That's another area of the world where the rights of nature is getting a foothold, and recognition of the values of ecosystems for so many, not only just services, but enrichment of human life on Earth. This is their constitution, and this is incorporating into their constitution the rights of Pachamama, Mother Nature, where life is reproduced and occurs, and a right to integral respect for its existence and so forth. Nature has the right to be restored. In those cases of serious permanent environmental impact, including those caused by exploitation of non-renewable resources, the state shall establish the most effective mechanism to achieve the restoration and shall adopt adequate measures to eliminate or mitigate harmful environmental consequences. The state shall apply preventive and restrictive measures on activities that might lead to the extinction of species, the destruction of ecosystems, and the permanent alteration of natural cycles. Sounds really good. Is it law? And so lots of questions. How actually do you define Mother Nature? Does it include things like pests and viruses and bacteria, tornadoes, floods, droughts? Read literally, the Constitution grants all of these the rights to restoration as well as the right to exist and regenerate. Who has standing? And in Ecuador, this is a real problem. They have a particular constitutional form of action, acción de amparo, but there's no jurisprudence on standing. It's not clear who among the citizenry of Ecuador has the right to actually bring these kinds of cases to court and secure remedies, and rights without remedies are just rhetoric. So the question is, what kinds of remedies can people get from the court? What are the causation and proof requirements that go with all those words you saw in the Constitution? And how much scientific evidence is required, and what will it cost, and on and on and on. How are damages calculated? Where does the money for the damages go? How do you know that it's going to be used for restoration? What happens when nature's constitutional rights conflict with human constitutional rights? And in a country like Ecuador, what do you do with a very weak judiciary? It's not an independent judiciary. It's subject to political power. There's a history of corruption, and so on and so forth. So these are the practical, real-world, reality challenges. The Constitutional Court in Ecuador did use the constitutional provision in at least one case involving a dam, a Baba multi-purpose dam, requiring, in essence, the Attorney General of Ecuador to go back and do what we would call an environmental assessment, and looking harder at the consequences. The upshot, of course, as is too often the case, is here. The dam was built, and the hydroelectric project was implemented, and this is the all too familiar story of a victory on process that did not change outcome. Colombia is another interesting area of the world to keep an eye on. Again, Colombian Constitutional Court granting the rights to the Atrato River, and requiring the government to clean it up, ordering the national government to exercise guardianship and representation of the rights of the river. And we'll have to wait and see how this is all going to play out. In the United States, we've had attempts to build on this notion of giving voice, actual voice to nature. In this very interesting case, the cetacean community against the President of the United States. A case was brought and litigated in the Ninth Circuit out of California. The court treated the argument with some respect, and said, we are asked to decide whether the world's cetaceans have standing in their own name under the Endangered Species Act, Marine Mammal Protection Act, and others. We hold that cetaceans do not have standing under these statutes. It's obvious that an animal cannot function as a plaintiff in the same juridically competent way as a human being, but we see no reason why Article 3 of our U.S. Constitution prevents Congress from authorizing a suit in the name of an animal any more than it prevents suits brought in the name of artificial persons such as corporations. The court ultimately concluded Congress had not done that in any of these specific statutes, but left open the possibility that Congress could. One thing that I thought I would note for you all, an upcoming symposium you might be interested in at Tulane University next week. It's quite a lineup. I was looking at it. There's the link. You can see for yourself. But they're bringing in a lot of the key players from these cases I've just quickly gone over around the world and in the United States to talk about these issues. So I thought you might be interested in knowing about that. I think there will be live stream and a podcast from the symposium. I'll close with my favorite author, the one who gave inspiration to my whole career, Aldo Leopold. Ethical behavior is doing the right thing when no one else is watching, when doing the wrong thing is legal. And with that, I'll close.